Resolution Act has been duly given and it is required to be passed by the votes cast whether on a show of hands or electronically or on a poll, as the case may be in favor of the resolution, including the casting vote, if any, of the chairman by members who, being entitled so to do, vote in person or where proxies are allowed by proxy or by postal ballot, exceed the votes, if any, cast against the resolution by members so entitled and voting. Types of resolution: ordinary resolution, special resolution, resolution with special notice, resolution by circulation, resolution to be filed. Director: the individuals at the highest level of management are responsible for the functioning of the company. These high level members of the company are called directors. Collectively, all directors as a group and the supreme acting authority of the company are called board of directors. The board of directors are can be called the brain of the company. They are responsible for taking all the big decisions and making policy changes. These decisions are taken in special meetings members of the board hold together, called board meetings. Section 149 of the Companies Act states that every company's board of directors must necessarily have a minimum of three directors if it is a public company, two directors if it is a private company, and one director in a one person company. The maximum number of members a company can assign as directors is 15. However, the company can pass a special resolution in a general meeting to allow for assigning more than 15 members to the board of directors. The maximum number of companies that an individual can become a director of is 20 companies. At least one director who has lived in India for a minimum of 182 calendar days of the previous year shall be appointed by every company's board. It is a mandatory rule. At least one woman director must be appointed by the company. All listed companies must have at least one third proportion of their board of directors as independent directors. 1. Act as the firm's agent. 2nd. Have full access to the firm's account. 3rd. Cause the firm to enter into valid contracts. 4. Lease the firm's assets. 5th. Borrow and give security. Appointment of director. This article provides a brief to the various classes of directors and their appointment according to section 234 of Companies Act 2013. A director is a person who is appointed as director in the company. A person who is appointed but not designated as a director will not be considered as a director under the meaning of this act. Minimum number of directors: in case of public company it is 3, private company 2, and one person company 1, though articles of the company might specify for a higher number of minimality. Maximum number of directors: it is 15, but more can be appointed by passing a special resolution. Requirement of a special resolution is not needed in government company and company licensed under section 8 subject to condition. Disqualification of directors: section 1 and 64 following are not eligible to be a director. A person of unsound mind, undischarged insolvent, person applied for to be adjudicated as an insolvent and his application is pending, a person who has been imprisoned for more than 6 months and 5 years have not elapsed, court or tribunal disqualifying such person, a person who has not paid any call on share and 6 months have elapsed, convicted in offense of related party transaction in preceding 5 years, a person who has not been allotted with DIN